Today I am here, however, for an announcement, and I am joined by Secretary Duncan from the Department of Education, U.S. Attorney David Hickton from the Western District of Pennsylvania, and the Attorney General of Iowa, Tom Miller. We have come together to discuss an historic step forward in our collective and ongoing fight against fraudulent and abusive practices in the for-profit education industry. Now today, we are announcing a landmark settlement with Education Management Corporation, which became the second largest for-profit education company in the United States. Education Management Corporation, also known as EDMC, operates chains of schools around the country under the brand names Argosy University, the Art Institutes, Brown Mackie College, and South University. EDMC enrolls more than 100,000 students, and approximately 90% of EDMC's revenue comes from taxpayers in the form of federal education funding for EDMC students. Now, this case not only highlights the abuses in EDMC's recruitment system, it also highlights the brave actions of EDMC employees who refuse to go along with the institution's deceptive recruiting practices. Beginning in 2007, two EDMC employees blew the whistle on EDMC by alleging that it was running a high-pressure recruitment mill. Essentially, the more students a recruiter was induced to enroll in the school, the more money that recruiter would receive. And these employees allege that EDMC's recruitment practices violated the incentive compensation ban of Title IV of the Higher Education Act, which prohibits schools from basing recruiters' pay on their success in securing new enrollees. Now, obviously, that ban is in place, so schools will account for the unique qualities and needs of potential students, rather than simply treating them as a vehicle for tapping into federal student aid funds. Now, despite their alleged conduct, EDMC has certified its compliance with the ban to the Department of Education for over a decade. Falsely claiming federal grant and loan money is a violation of the False Claims Act. And in 2011, the United States intervened in the case alongside 5 individual states: California, Florida, Illinois, Indiana, and Minnesota. And since that time, we have aggressively pursued justice in this case on behalf of the students and taxpayers that the incentive compensation ban is designed to protect. Now, under the settlement that we are announcing today, EDMC has agreed to pay $95.5 million to resolve the claims that it falsely obtained federal and state education funds. This makes this the largest False Claims Act settlement with a for-profit educational institution in history. The unprecedented size of this payment and the stringent compliance measures that EDMC has accepted reflect the fact that this kind of abuse hurts not only taxpayers but also the students, many of them non-traditional learners like veterans, older Americans, and working parents who trusted EDMC to provide an education that would address their individual needs. EDMC's actions were not only a betrayal of their students' trust, they were a violation of federal law. Now, this resolution exemplifies the Justice Department's deep commitment to protecting precious public resources, to promoting compliance with the law, and to standing up for those who are vulnerable to exploitation. It's an extraordinary accomplishment both for the men and women who fought to achieve it and for future EDMC students and students at educational institutions across the country who will no longer be victimized by unacceptable recruitment practices. Now, in the days ahead, we'll continue working with our partners at the Department of Education through initiatives like the Interagency Task Force on For-Profit Education to ensure that our nation's aspiring learners are finding and gaining access to educational opportunities that are right for them and that will help them thrive and achieve for many years to come. Now, today's resolution would not have been possible without the efforts of our remarkable team here at the Justice Department, including staff from the Civil Division, as well as the U.S. Attorney's offices in Pittsburgh and Nashville, Tennessee. I also want to convey my deepest appreciation to our colleagues at the Department of Education and its Office of Inspector General for their close cooperation as well. And I'd also like to recognize our many state partners for their indispensable leadership in bringing about this historic result. This case is not only an example of what we can achieve when we work together, but a demonstration of the values and the commitment and the mission that we all share. And now at this time, I'll turn the microphone over to the Secretary of Education, Arnie Duncan, who will provide additional details on today's announcements. Mr. Secretary?
Thank you so much. Thank you all for being here, and thank you so much, Attorney General Lynch, for your extraordinary leadership and that of your team. And thanks to the Iowa Attorney General, Tom Miller, and U.S. Attorney David Hickton for their partnership and real leadership on this tough issue. As the Attorney General did, I also want to thank our Inspector General, Kathy Tai, for her leadership on behalf of students and taxpayers. And I want to thank our higher education team and our General Counsel's office for all of their hard work here as well. Now, more than ever before, a college degree is the best path to the middle class. But that path has to be a safe one for our nation's students. Every hardworking student in this country must have a real opportunity to achieve a meaningful, affordable degree. America's commitment to upward mobility, the strength of our economy, and our identity as a land of opportunity depends on that. But unfortunately, not every institution of higher education is focused on providing those types of quality opportunities. In fact, some take advantage of both students and taxpayers by gaming the system and not following the rules. Others outright lie about their practices, which was exactly the case here. The Obama administration has led unprecedented efforts to protect consumers from predatory career colleges. We've cracked down on fraudulent behavior, reining in bad actors that saddle students with debt and worthless degrees. We believe that it's critically important both to protect students and taxpayers from programs that fail to provide a quality education that leads to success, and to empower the public with better information around educational outcomes. Today is just another step in that fight to improve accountability and protect both students and taxpayers. In fact, as Attorney General Lynch said, it's the largest False Claim Act settlement against an educational institution. Simply put, EDMC wasn't interested in playing by the rules. Through this multi-year investigation led by the U.S. Attorney Hickton's office and the Department of Justice, and supported by our department and the Office of the Inspector General, we uncovered substantial evidence that EDMC illegally paid recruiters based upon how many students they enrolled. Instead of caring about whether a student would be successful in EDMC's programs, the company seemed to only care about revenue at significant cost both to students and taxpayers. EDMC got nearly 90% of its revenue from federal financial aid. That's all of our money, all of us as taxpayers. I want to thank and say how proud I am of all the folks who worked so hard to challenge the status quo. The settlement should be a very clear warning to other career colleges out there. We will not stand by when you profit illegally off of students and taxpayers. The federal government will continue to work tirelessly with states' attorneys generals to ensure that all colleges follow the law. While many post-secondary students face unique challenges and hurdles, those who are enrolled in for-profit and career training programs, as the Attorney General talked about, are often among the most vulnerable. These students absolutely deserve to go to a college with a real understanding of what that college, what the value of that degree will be, and what that certificate will mean for their future earnings. A quality education that leads to good outcomes, like a well-paying job and a strong future, is still the best investment. It's the best investment that anyone can make in themselves and their families. Students seeking a better life simply shouldn't have to pay a penalty for following their dreams. I'll stop there and I'll turn it over to U.S. Attorney General David Hickton. He and his team have been working on this extraordinarily hard for 4 years, and I want to thank you so much for your hard work and leadership.
Thank you. Good morning. Fraud against American taxpayers can never be tolerated. Such fraud is especially destructive when it victimizes students who are hungry for an education in order to achieve a better life. Over 4 years ago, the United States intervened in a qui tam brought in Pittsburgh against Education Management Corporation, alleging that it illegally paid incentive compensation to its recruiters and lied to the Department of Education about its misconduct. Today we announce an unprecedented and comprehensive resolution to that hard-fought litigation. Our complaint alleged systemic false claims by EDMC. In essence, we determined that EDMC implemented an illegal compensation plan for its recruiters and admissions personnel to obtain billions of dollars in federal funds. EDMC pledged to the United States that it was not paying incentive compensation, when in fact it fostered a high-pressure boiler room sales operation that resulted in its recruiters' use of abusive tactics to enroll students. These practices enabled EDMC to become the second largest provider of for-profit education in the United States. EDMC made constant efforts throughout the litigation to trivialize our allegations as mere technical violations. In fact, the violations tainted the very fabric of EDMC's educational mission, and the settlement we announced today demonstrates our unwavering efforts to hold EDMC accountable for its breach of trust with the United States and its students. Today's announcement also signifies another major achievement in our district's effort to combat education fraud at all levels. Our district prioritized the prosecution of fraud in our education system over 5 years ago when we established a first-of-its-kind education fraud hotline in Western Pennsylvania. We have indicted, among others, the CEO of the largest cyber charter school in Pennsylvania for fraudulent abuse of taxpayer funds. Today, we reaffirm our commitment to eradicate fraud in our education infrastructure by announcing the largest settlement ever in the for-profit education sector. We do this because it is a priority of this administration, this president, this Attorney General, and the Secretary of Education. But we also do it because we recognize that investing in education remains the best way for us to retain our standing in an increasingly competitive global economy. A fundamental compact exists between the government and the public that prioritizes the funding of an education system accessible to all and free from fraud and abuse. Through its prior practices, EDMC threatened that compact by violating the trust upon which it is based. EDMC turned that compact on its head by placing the pursuit of profits ahead of a legitimate educational mission. Our global settlement marks a turning point for EDMC and the entire for-profit education community. We are deeply grateful for the work of our partners at the Department of Justice and the Department of Education and the 43 states that joined with us in that effort. This landmark global settlement reflects a watershed in our efforts to ensure that all of our nation's students have an equal opportunity to a quality, affordable higher education. Thank you. I'd now like to turn the podium over to Iowa Attorney General, Mr. Tom Miller.
Thank you. In addition to the false claims settlement, the states are announcing, indeed the Attorney Generals of 39 states in the District of Columbia are announcing today a consent decree agreement with EDMC that covers a broad range of activities, including and especially the marketing and recruitment activities, claims concerning job placement, and other ways they relate to the students. It's a bipartisan agreement involving 20 of the 27 Republicans and 19 of the 23 Democrats, and is broad-based, as I mentioned. One of the key areas is in recruitment, as the false claims directs as well, concerns about boiler room. There are broad prohibitions about unfair, deceptive, misleading claims made in the recruitment process, and abusive recruitment methods. Sort of a new term for us in AG enforcement, but that looks towards the so-called pain pressure way of recruiting students. There are broad prohibitions about false claims in the job placement area. We've negotiated for months over those provisions, and there's great detail in terms of what they can and can't do in terms of job placement. In any area we have found in the state AG world is that where there's a culture or a semi-culture of fraud, you're not going to change that by an agreement alone. You need to monitor. and you need a monitor that can make sure the agreement is lived up to. We think we have the best possible monitor. Tom Pirelli, the former Associate Attorney General that worked so hard in this building, and more significantly, in a way, he's been in the monitor in the Bridgepoint Ashford case of over a year and a half, and that has worked well. There are other provisions we think that are important for students in our agreements with EDMC. One has to do with the students that are recruited that really shouldn't have been recruited for a variety of reasons. It doesn't work for them. They're not. They don't have the background for it. Maybe they don't have the computer feasibility with it. So this provision is directed towards them, but others as well. If you are a student of theirs and have less than 24 hours credit post high school, then there's an orientation program to educate you, to make sure that you understand what you're getting into. And if you leave during the orientation program or after, there's no cost and no loans. And for the same group of students, for 21 days in online education and 7 days on campus, if they drop out, if it's not for them, there's no cost, there's no loans. Another problem that we run into is students sign up for a 4-year course often. They complete the course, get the degree, and find out they can't be licensed in their state. This is typically done in elementary and secondary education, where students don't have practice teaching. This agreement provides that they cannot enroll students in states where they can't get their license based on their degree. There's additional, it's built on in terms of the acceptance of this degree or this accreditation in the job market. If there are relatively few jobs that are open, they cannot enroll those students as well. In this whole area of education and consumer protection generally, there's a lot of disclosure. In a way, there's too much disclosure, and people get overwhelmed, and none of it gets through. Well, what we've tried to do is two things so that it does get through to people. One is our one-pager that students will receive. And that will have the number of months that they're going to be in the program, the amount of money, how many people complete the program, how many people out of 10 default, and if you do complete the program, how many people get jobs, the average salary for graduates, and the average debt, and is so that people can relatively see that and understand it. And in addition, we have something that's really new in consumer protection in our area, and that is an interactive provision, so that students have to feed in their information to some extent. And basically what it looks at is how much the program cost, how much you have to pay back, and how much income you're going to have. Those basic numbers so that people have that. In addition, lead generators have been a serious problem in the recruitment area. They're unregulated for a variety of reasons, although we're trying to change that. And they're out on the internet saying and doing anything to get leads that they sell then. There are provisions in the agreement with EDMC where they have to restrict what the lead generators do, and they and the monitor, Tom Pirelli, have to monitor the lead generators. There's provisions for refund or forgiveness of loans in this agreement with EDMC. $102,800,000 in loans that are owned to EDMC. It's about 80,000 students. It's about $1,370 on average, and it affects those students over a 9-year period that had less than 24 hours credit and left within 45 days of enrollment. Again, to sort of look at that group that are unfairly recruited. We believe that this agreement has been well negotiated on both sides. We negotiated for over a year. We think it was good faith negotiations. We recognize the work that Meyer Koplow, Carol DeBattiste, and the leadership of the company brought to these good faith negotiations. We think that this agreement is an agreement that can be used with other companies as well, and we look forward to that. And I would like to, in closing, acknowledge the great work by the 6 Attorney General's offices that were on the executive committee: Connecticut, Kentucky, Pennsylvania, Oregon, Illinois, and our state of Iowa. Thank you.
Thank you, Tom. Thank you, Tom, and thank you, everyone. I'm not sure who had their hand up first. I'm just going to start in the middle and then come back to the first one.
I wanted to start with one question for Secretary Duncan and then come to you, Attorney General Lynch. Just on this actual settlement, there was mention there about students that were affected by this, kept talking about how they are victims. What is this, can you expand on what the settlement does for past or current students of these programs? And this issue has come up with the Corinthian case. What do you do with people that have incurred substantial student debt and didn't get a career out of this?
So this is a little bit different than Corinthian, where that was misrepresentation to students. What we're talking about here is basically not following the law, breaking law, and lying to us. But we are open for business. Where students were lied to, we want to have that conversation and we'll move forward.
And Attorney General Lynch, I wanted to ask you about some comments that CIA Director John Brennan made this morning in the wake of the Paris attacks. He said that there are legal and policy and other developments that have taken place, changes that have taken place recently that have caused certain intelligence gaps that are making it more difficult for intelligence agencies to foresee attacks like the one that took place in Paris. Do you agree with that? And can you be any more specific about what legal or policy changes may have gotten in the way here?
Well, I'm not able to provide any more specifics than what Director Brennan did. I will say that certainly we continue to have our ongoing discussions regarding our ability to safely and effectively and efficiently and legally collect information while also preserving privacy interests that are very important, not just to American business, but to the American people. We've had this discussion before, and I think that they're the subject of ongoing discussion. So I'm not able to comment further on what Director Brennan said, except to say that we take these issues very seriously, as does American industry. And so all of us are looking at these issues very, very carefully. And I'd say.
Now, the theory has been floated that these terrorists may have used encrypted technology. Is there any concrete evidence that they actually took advantage of encryption? And also, what tools do you need to continue to try to prevent an ISIS attack here in the U.S.?
Well, I'm not going to comment specifically on emerging evidence in the case for obvious reasons. I'm not able to go into the specifics of that. What I will say is that, as we've discussed in the past, terrorists use any number of means to communicate, including some encrypted means, and we've seen that in cases that have surfaced in here, for example, Garland, Texas, and the like. And we've seen that as terrorists try and persuade American lone wolves to imitate them and to act as well. For us, this is an issue in which we recognize not only the importance of encryption, but the need to do everything that we can to protect the American people. And as we've stated, we are pursuing a number of options. We're in discussions with industry looking for ways in which they can lawfully provide us information while still preserving privacy.
More broadly speaking, given the sort of the evolving nature of the ISIS threat, what specifically is the Justice Department and FBI doing to keep America safe? There's obviously this threat reported against Washington, D.C. that ISIS made. How secure are we right now, and what are you doing to ensure that what happened in Paris doesn't happen here?
Well, let me say at the outset that protecting America from another terrorist attack, indeed, protecting the American people, is indeed my highest priority as Attorney General. It's the highest priority of this Department of Justice and this administration. So we are certainly continuing ongoing efforts that we always have to monitor details that we learn of and to make sure that we're taking the appropriate steps to ramp up our defenses. We take every threat seriously. We conduct the appropriate investigations, and this is something that is subject to ongoing review in terms of our own actions that we undertake to protect the American people. I'm not able to get into the specifics of those. Certainly I can tell you that with respect to our fight against ISIS, the issue of foreign terrorist fighters leaving the U.S. is one that has been of great concern to us here at the Department of Justice for some time. And as we've talked about, a number of individuals have tried to leave the U.S., much, much smaller numbers than Europe. We have far fewer people who make that effort and who return than Europe, but still it's something that we take extremely seriously, and there are a number of cases against individuals who have attempted to leave and provide material support in Syria. And,
question about the settlement. Several of you refer to it as unprecedented and as a warning to the sector. There are many people out there who are calling this kind of a pretty paltry number, considering the billions that have been have gone to this company. Can you comment on why you think this is some kind of a fair number compared to the amount that the government has paid out to EDMC over the years? And also to Secretary Duncan, if you could explain, are you saying that this has no effect on the students' loan discharges for those who attended?
I'll defer to Secretary Duncan on both those questions. Let me just say at the outset that an important part of this settlement was factoring in the company's ability to pay. So it does not reflect the total amount of federal funds that we believe were fraudulently obtained. You are correct in that we think that their widespread practices did generate a substantial drain on the public fisc there. And with respect to your question on the students, I'll ask Secretary Duncan to speak to that. Thank you.
So again, to be clear, what was found here was not misrepresentation to students. It was breaking the law and lying to us. And if there is evidence of misrepresentation to students, we want to hear that, and we're open for business.
One-on-one case, in other words.
One-on-one cases, we'll continue to look at it, we'll continue to investigate, and where students have issues, please let us know.
So was the CFPB brought into this discussion at all?
I'm sure they're aware, I don't know to what level.
We'll take one more question.
Madam Attorney General, with all the arrests that you mentioned, how would you describe the current threat from ISIS to the U.S., and what do you expect the public to do over the next weeks and months?
Well, I think that with respect to our view of the threat that ISIS poses, they certainly are one of the most deadly terrorist organizations there. We are always watching and always vigilant to determine their impact and whether or not they have sufficient reach within the U.S. to carry out similar attacks. I think the cases that I mentioned again talk about individuals who have been seeking to leave and become what we call foreign terrorist fighters. A number of them have been prosecuted. And while those numbers are indeed far fewer than Europe has seen, obviously they're of great concern to us, and so we are monitoring that situation. What I would say is to urge all Americans to continue as we have since the deadly attacks on our own shores, to be vigilant, to be on the alert, and to look out for attacks that, as we've seen in the past, but to not let this change either our way of life or our values.
Do you feel like there's adequate intelligence sharing with our European counterparts to prevent people like the Paris attackers, who we know went over to Syria and trained, from boarding a plane and coming to the U.S. given the visa waiver program?
Well, I'm not going to get into the specifics of the information that we share with our foreign counterparts, except to say that our relationship with our European counterparts in this area is robust and it is strong, and we are always working to make sure that not only we, but they also have the information that they need to safeguard against these incidents and specific people if we learn of them. So.
That's all. Thank you so much.
A Syrian